Today I'm going to talk about something that seems to come up as an afterthought when doing estate planning with clients, and that is what's going to happen to any pets or livestock that the clients may have at the time of their passing. So pets and livestock are treated like personal property. So just like your couch, the legal term is chattel. So if you think of chattel like cattle, and then there has to be some sort of instructions as far as what happens to your personal property. So most wills and trusts will have a catch-all language that says split things up amongst my family members or amongst my beneficiaries, but that might not be the intent that you have in mind. So I'm going to talk about that today. My name is Shawn Eyestone. I'm a West Michigan estate planning attorney, and we deal with this issue quite often. And really, there's just three things that you have to address when planning for your pets. First of all, who's going to care for your pets? How are they going to be cared for, and what type of care is going to be provided? So first of all, most people look to their family or their friends, and if the family and friends aren't the right fits for your pets, then sometimes you can look to organizations. So if you have an old horse, sometimes there's sending farms where old horses go, and cat rescues and sanctuaries and things like that, no-kill shelters, lots of things. We can think out of the box with that, but for most people, it's family and friends. And you want to pick somebody, number one, who's willing, so you don't want to make it a surprise for anybody. And then somebody that's going to follow out and do the things how you want them done when you want them done, which gets us to the next point. How are you going to get these instructions to the people? Most people use an informal approach. So they'll verbally say, hey, I want Susie to take care of my cat, Fluffy, or I want Jim to take care of my dog, Yeller, or whatever the case may be. And that may be fine in most cases, as long as everybody gets along and there's not any disagreement with that. But verbal promises are not enforceable. So there's a lot of people out there, lawyers, who are really pushing the idea of putting together a pet trust. And again, for most people, a pet trust is probably more than you need. So a pet trust would provide all of the things that you need, the who, how, what, and would have a way to fund that. How are things going to be paid for? The pet trust can provide for all of that. If you have a pet that's going to be long living, you've got a parrot, you've got a tortoise, you have a horse that you recently bought that maybe has got 25, 30 years left of life, and there's a lot of expense that goes with it and nobody is willing to just take it on, maybe you set aside a bunch of money with a trustee to gradually dole those funds out to the person caring for that pet. But for most people, that's more than you really need. So a pet trust, really any trust in Michigan, for it to be economically viable under the statute, has to have roughly $90,000 in assets or more. Anything less than that, the beneficiaries can petition to wind up the trust and get the money outright with any plausible reason. Courts really don't like dealing with personal property, even if it's a pet, even if it's a horse. So they're not going to likely give it too much time and attention like they would if, we're talking about millions of dollars. Maybe if you own a racehorse that's worth millions of dollars, it might be worth doing. But again, most people don't do that. And for most people, we do offer pet trusts, but it's not usually a practical solution. So for everybody else, typically what we recommend is that you have a provision in your will or trust that allows for a written memorandum of instructions for your personal property. In our written memorandums, we allow people to have both personal property and some cash to go along with it. So I want Susie to take care of my cat, Fluffy, and here is $3,000 for her to take care of it. Really no strings attached. You're trusting her to figure it out. Nobody's going to have to try to enforce it. So the next thing is, what do you want them to do is the other thing that you would provide for either in the pet trust verbal instructions or in the written memorandum. And that is anything from, the care and feeding. If there's particular ways you want the dog or cat or horse or whatever fed, you could lay that out. Healthcare, surgeries. Are there financial limits that you want to put or give permission? Because that's something that we see a lot of times is there's not the permission. People don't feel like they have a permission to put someone's dog down. For example, if your child gets your dog and your dog is sick as well after you pass away, that's the last connection that they may have to you, so they may be less likely to euthanize the dog and maybe prolong the dog's life longer than is healthy for them and for the dog. If you've had any veterinary care done lately, sometimes it can cost you $2,000 just to find out what's wrong with the dog or the cat. And then it might be $5, $6, $7, $8, $10, $15, $20,000 for surgeries, cancer treatments, etc. So are these things that you would want and expect your loved one, family member, friend, organization to do, or would you give them permission at this point to euthanize the pet? So just having that written verbal permission a lot of times alleviates a lot of the stress that can arise from that. So what we do with our clients is we help create a plan that actually works. So with your circumstances, with your assets, with your goals in mind, helping you put together a plan that works, that's practical. That's going to actually work when the time comes, that's affordable for you and your family, and most importantly, cares for your pet in the way that you would want to. So if you're looking for some help with that, we can help do that, as part of your overall estate plan or as an addition to an existing plan that you have. Give us a call, 616-777-5291. You can follow the link to our website and schedule a consultation there. We don't have any charges for the initial consultation when we meet with you and give you some ideas as far as where you're at and what we could do to help you. So again, my name is Shawn Eyestone, estate planning attorney in West Michigan. Give us a call and we can help you out.